Good morning, everyone. Welcome to our first panel discussion at this conference organized, thank you, Jacob and Victor, by Jacob and Victor. Our first panel discussion concerns constitutionalism and constitutional institutions. We're very lucky to have three panelists who have provided three glittering papers for our reading enjoyment and immediate discussion now. For the benefit of those who may not have been with us earlier this morning when Jacob explained proceedings, what we will do is, in a moment, I will briefly introduce our three panelists, and then in alphabetical order, they will speak to their papers for about 15 minutes. I'll have a few comments when they are done, and then we will open the queue to questions and contributions. There are a lot of us, so I would encourage those of you who would like to ask questions to please ask questions as briefly as you can, so we can allow as many to participate as possible. Without further ado, then, I'm Evan Fox-Decent. I'm a professor at the law faculty at McGill and very proudly and happily a member of the research group on constitutional studies. Our first panelist is Arash Abizadeh, a colleague at McGill in political science. Our second speaker today will be Yasmin Dawood from Toronto, who's cross-appointed to law and politics. And our third speaker today will be David Watkins, who's a professor in the political science department at the University of Daca. So without further ado, Arash.
Thank you, Evan. Thank you, and thank you to the organizers, Jacob and Victor. Thanks for inviting me, and thanks for everyone for being here. I'm sorry that we couldn't have you all here in Montreal right now. I can't tell you how sorry I am about that. So let me just start off by saying that this is actually a recently published paper, and I'm sorry about that. Usually I don't present published work. But it seemed so fitting for the conference theme that when Jake asked me to do it, I readily and happily agreed to do so. The paper, as you might be able to tell from the title, is an attack on the majoritarian conception of democracy. So that's where I want to start. Many people equate democracy with majoritarianism. They think that majority rule is at the heart of democracy. This is what I call a majoritarian conception of democracy. And on this majoritarian conception, basically it's constituted by two claims. First is that departures from majority rule are derogations from democracy, and that majority rule is justified by reference to the core commitments of democracy, normative democratic theory. And these two core commitments, I take them to be political agency, which comprises participation, and power. So it's that people have power, agential power in decision-making process, and that they participate in decision-making processes. And the second component of democracy I take it to be political equality. So equal participation and equal power in decision-making. So the majoritarians think that majority rule is justified by reference to these core democratic commitments, and that departures from majority rule are derogations or compromises or limitations upon democracy. And the upshot of all of this is that counter-majoritarian institutions, such as federalism, consociationalism, derogate from democracy, or they are some kind of constraint or limit on democracy. And actually another upshot is that representation is a limit on democracy, because after all, representation is a departure from strict majority rule. So majoritarians, as I understand them, could think, and often do think, that these kinds of arrangements are justified, perhaps all things considered, but they're justified by appeal to values or principles that are extrinsic to democracy itself. In other words, they might be all things considered justified, but majoritarians want to say, nevertheless, they are compromises of or derogations of democracy. And this is the view that I want to attack in two ways. But before I do that, just give you some kind of, situate this more personally, where this is all coming from. I mean, the intuitions that were sort of boiling around in my head before I actually managed to articulate this in an analytical fashion. A lot of it is just personal context. So living in Canada, and in particular living in Quebec, none of this makes any sense to me, this majoritarian conception. And why does it not make any sense? Because here's a question: how could members of a persistent minority, let's take French Canadians who are concentrated in Quebec, be treated as political equals in a democracy? Not by majority rule, not by majority rule. So that's the kind of fundamental intuition that is behind this. And obviously the second context is living in a federal system where it looks to me, at least intuitively, that federalism, precisely because of this persistent minority problem, is something that serves rather than derogates from democracy. So those are the kind of intuitive bases for this. And also one last sort of, I think, motivation for having written this paper was the sense that majoritarians like Waldron, for example, when they are giving justification for their majoritarianism, often seem to be presupposing in their arguments intuitions that hover around notions of direct democracy, and then simply, and then things get very weird when it turns out, oh, actually they're talking about representative democracy. So those are sort of the kind of intuitive bases for this project. Okay, so let me get to the argument. Basically, there's two. The majoritarian conception of democracy is mistaken for two reasons. First of all, it's incoherent. That's going to be the first leg of the argument. And second of all, it is premised on a incomplete but widely spread view of power. Okay, so it's incoherent. Why? The fundamental claim is that majoritarianism actually stands against one of democracy's two core commitments. And this might be surprising to you, because often majoritarianism is justified by reference to the democratic commitment to political equality. And what I'm going to argue is that actually majoritarianism stands against political equality. Okay, why is this the case? Well, let me give you first a definition of majoritarianism. I take majoritarians to be committed to what I call the general majoritarian thesis, which is that all things equal, the closer that you get to majority rule, the better. Okay, so that's the general majoritarian thesis. And of course, one implication of that is that majority rule, strict majority rule, is the best, all other things equal. Okay, all right. So this all other things equal clause is important because for majoritarians, at least moderate majoritarians, you're still all things considered, departures from strict majority rule might be justified for practical reasons or for reasons, normative values extrinsic to democracy. But within those constraints, the majoritarian wants to say, you have to come as close to majority rule as possible within those constraints. And secondly, any departure from majority rule, even if it is justified, compromises democracy. It's just that all things considered, we ought to compromise democracy on this moderate majoritarian view. Okay, that's exactly what I want to contest. So what are the justifications for a majoritarian conception of democracy? Well, typically what majoritarians argue, one thing that they'll say is, well, notice that majority rule satisfies, this is the appeal to political equality. It satisfies the condition of equal a priori voting power. And what this means is, what is a priori voting power? This is a technical term in the literature on voting power, is that it's the voting power that you have, strictly in virtue of the formal institutional structure of decision-making. Okay, once an agenda of decision-making has been given exogenous. Okay, so, you have equal a priori voting power if, for example, everybody has one vote and it's majority rule, right? That's equal a priori voting power. Majority rule also satisfies anonymity. These are formal social choice conditions, and neutrality. And that's what's supposed to explain why it serves the democratic value of equality. Also, sometimes people also appeal to agency. And the idea here is that actually the closer that you get to majority rule, we can show this, I formalize this in the paper, the greater overall a priori voting power of voters becomes. So actually, it turns out that mathematically, the general majoritarian thesis, which is come as close as you can to majority rule as possible, is equivalent mathematically to maximizing overall a priori voting power amongst all the voters. So that's a kind of, it serves the democratic value of agency. So notice what happens now is that federalism on this kind of view is straightforwardly a derogation from democracy because it violates equal a priori voting power, it violates anonymity, it violates neutrality, and it violates the maximization of overall voting power. But there's a problem. And the problem arises once we move to non-ideal, if you want to call it that, conditions, but these are the conditions of everyday life where, all things considered, you shouldn't really adopt strict majority rule, which majoritarians by and large acknowledge because of practical constraints, other values, and so on. It turns out that once you depart from the strict majority rule, but you're trying to come as close as you can to majority rule as possible, that mathematically, that's equivalent, that sometimes actually requires you to increase inequality in voting power, and in fact, sometimes requires you to disenfranchise some voters. That the core constitutive commitment of majoritarianism to come as close as possible to majority rule under non-ideal conditions effectively abandons the value of political equality. So that's the crux of it, and I show this through various formalizations in the paper. So majoritarianism actually stands against one of the core commitments of democratic theory, which is political equality. And that's why it's incoherent. Okay, so the second leg of the argument, which is that even if majoritarianism did not jettison the democratic commitments to political equality, let's say it didn't do that, the second point is that it can't explain the inequality that is faced by members of persistent minorities. So for example, if we adopted majority rule in Canada for political decision-making, French Canadians would always be outvoted on matters of culture and language and so on because of their persistent minority status. Now, the issue here is not just that they would always be unsuccessful and that poses a problem for political equality. It's also that, and this is a problem for democratic equality, is that members of a persistent minority don't exercise and don't enjoy equal power in decision-making. And so it's not just about unequal prospects for success, it's about unequal power in the process, which is the affront to democratic equality. Now, how do I show this in the paper? Well, I show that, first of all, the majoritarian conception of power, agential power in decision-making, can't explain this inequality. Why? Because they only look to, at most, two sources of political power, which ought to be equalized in democratic decision-making. The first is the power that you have in virtue of your standing in the formal institutional rules of decision-making. So for example, you have one vote, everybody has one vote in majority rule decision-making. That's your standing in the formal institutional rules that gives you a priori voting power. Majoritarians could also acknowledge the significance of informal voting power. So for example, the power that you have over those with formal standing. The power, for example, to shape people's preferences. A majoritarian might say, well, look, not only should people have equal a priori voting power, but also we should try to equalize the influence that people are capable of exercising over each other in shaping their preferences and so on, right? That's consistent with the majoritarian. I'm willing to grant this, but what a majoritarian cannot see is what I call the power of numbers. And that's to say, it's the agential power that you have to effect outcomes in virtue of the fact that there are others who are disposed to act in concert with you. This is what I'm calling the power of numbers. So for example, there may be social structures that you occupy a particular position within those social structures, let's say structures of ethnicity or race or primary language or so on, where these structures shape preferences in a systematic fashion such that they correlate in a way that you have the advantage in the decision-making process in virtue of the position that you occupy in those social structures, such that when you want something conditional on you favoring some policy outcome, others will also favor it in the majority too. That's the power that you have, the power of numbers. That's the kind of power that a member of persistent majority has that a member of persistent minority doesn't. And we can capture this idea through the notion of a posteriori voting power, which is the voting power, and there's various ways to measure this, and I talk about this in the paper, is the voting power that you have in light of not just the formal institutional rules, but also, for example, the probability distribution of the vote configurations, which is a function of the structure of preferences amongst the voters and potentially also the structures of strategic interaction amongst the voters. So it's about the probability distribution of the vote configurations. Using these kinds of formal measures, we can show that members of persistent minorities are going to have zero voting power, for example, if they're always going to be unsuccessful. They never contribute causally to the actual outcome, whereas members of persistent majorities have positive voting power. Therefore, there's an inequality of voting power that is grounded in the position that people occupy in social structures that are not reducible to the formal institutional rules. What's the upshot? The upshot is that in order to compensate for unequal voting power in virtue of these other social structures, you may need to establish formal procedural inequalities. In other words, unequal a priori voting power. And that's exactly what arrangements like federalism sometimes do. Let me just qualify everything that I'm saying here. I'm not saying that counter-majoritarian institutions always serve political equality. That would be absurd, and it would be a ridiculous claim. What I am saying is that depending on the distribution of power within a particular society, counter-majoritarian institutions could serve under those particular conditions. They could serve political equality in order to compensate for inequalities of decision-making power that is grounded in other kinds of social structures. In other words, democratic equality may need these counter-majority institutions like federalism. And I would argue that in the particular Canadian context, federalist institutions do serve democratic equality, given the fact that we are a political community that has a territorially concentrated, persistent minority within the political society that we live in. So that's the general paper, and I think I'll end there I'll end here with one last remark, and that is that I know that this argument is a very difficult argument for our southern neighbors to swallow because of their particular history with federalism and its relationship to inequalities. It's a very different context. So this isn't a kind of, I think, there's a tendency for U.S. Americans to equate federalism with being intrinsically anti-democratic. And yet, what I would argue to our southern neighbors is that that's an artifact of your particular history. Whether it's true or not, I'm not qualified to judge. I suspect it is true, but if it is, it's an artifact of your particular history. It's not intrinsic to federalism that it be counter-democratic. It's in fact the kinds of arguments that try and show that it's intrinsically are themselves anti-democratic in my view. So what I would sort of leave you with is that there is no way that one should equate democracy with majoritarianism. Majority rule and majoritarian principles are a tool, one of the tools in the toolkit of democratic institutions that can be used to serve democratic values of political agency and political equality. But it depends on the circumstances.
All right, thank you, Arash. Yasmin?
Thank you so much, Evan, and also thank you so much to Jacob and Victor for the invitation to take part in this conference. It's really wonderful to be here with my co-panelists and also with all of you. So my paper is entitled Effective Governance and the Two Faces of Constitutionalism. And I think it's fair to say that we are witnessing in the world today what might be described as a crisis of effective governance. So basic governmental functions such as ensuring widespread education, healthcare, a strong economy, and the like are deeply compromised in many countries. And I think the global pandemic has reinforced the crucial importance of effective government. And it's also revealed just how terrible things can get with an ineffective government. So this is obviously a terrible state of affairs on its own account. But in addition, I think some would say that ineffective governance is one of the reasons why people have been tempted to elect demagogues or authoritarian figures to office because these people promised to fix the dysfunction, and this has, of course, precipitated democratic decline in certain countries. This paper is part of a collected volume entitled Constitutionalism and a Right to Effective Government, and it's forthcoming with Cambridge Press. And the volume examines the relationship between constitutionalism on the one hand and effective government on the other. So in my particular paper, I start with two questions. First, when we talk about constitutionalism as a concept, does it contain a commitment to effective government? And second, when we talk about effective government, do we think that constitutionalism is required for its functioning? So just to define terms at the outset, let's assume that effective governance means something like government that works, and let's say that constitutionalism means government that is constrained by law. So if we look around the world, we have something of a puzzle at the outset. We can see that certain governments are effective, but they guarantee little in the way of rights and freedom, for example, authoritarian regimes, which have robust economies, while other governments protect rights, but are lacking in efficacy, for example, democracies with weak economies and/or compromised public services. So in this paper, my objective is to try to shed some light on this puzzle and to explore a little further what I think is actually a very complex relationship between constitutionalism and effective government. So I have three brief points to make. First, I suggest that we ought to pay more attention to the two faces of constitutionalism when we think about effective government. So constitutionalism is conventionally understood, as I mentioned earlier, as government that's limited by law through such mechanisms as rights, separation of powers, federalism, and so on. These mechanisms are said to reduce the ability of the government to abuse power. Yet, as some scholars have argued, constitutionalism has a second function, which is to establish the institutions and processes of government. And in fact, several scholars have argued that indeed the purpose of a constitution is to enable a democratic form of government. Alternatively, as other scholars have argued, an important objective of a constitution is to create an effective working government. And I think that the framers of the US Constitution had a dual view of constitutionalism much along these lines. So in the political thought of the founding era, constitutionalist structures were viewed as necessary to safeguard liberty from arbitrary state power. And at the same time, the Constitution was viewed, as Madison put it, as a bill of powers, which established the institutions through which the government's power was generated and exercised. So I'm very much in favor of a more capacious understanding of constitutionalism, along with others who've argued for the same. One that includes both the conventional power limiting phase and in addition includes a power generating phase that is focused on establishing a government that works. All right, my second point, I think that a focus on these two faces of constitutionalism, power generating and power limiting, gives us a better grasp on the relationship between effective governance and constitutionalism. So in the second part of the paper, I focus more narrowly on the relationship between effective government and constitutional rights to show that it's actually quite complex, but I do in addition consider constitutionalist structures more generally. And I offer a typology of four possibilities. I should say this typology is by no means comprehensive. It only seeks to capture a preliminary sketch of some of the main possibilities. Okay, so the first category, very briefly, effective governance and rights. And I think there's a good reason to think that these two things are mutually reinforcing because rights and other constitutionalist mechanisms can check corruption and the abuse of power. But by the same token, effective governance can protect rights in both a negative sense, basically by not violating rights, but also in a positive sense by furnishing social and economic rights or by providing the conditions under which such rights can flourish. The second category is effective governance without rights, and authoritarian regimes can govern effectively in the sense that they provide for the needs of society by appropriately managing public resources and public affairs, and they can do this without rights, that is, without constitutionalism in the power limiting sense. But I think that authoritarian regimes do have constitutionalism in the power generating sense. And as several scholars have shown, including participants in this conference, and as was discussed in the first panel, not only do authoritarian regimes have the institutions and structures of governance, but these constitutions play multiple functions. They allow for coordination, the management of conflict, and the organization of official action, among other things. There's also been much work done on the wide spectrum of hybrid authoritarian regimes. And I think what's going on here in these hybrid regimes is that they all have constitutionalism in the power generating sense, but they have varying degrees of constitutionalism in the power limiting sense in terms of things like rights. Okay, the third category, ineffective governance and rights. So I think government ineffectiveness or effectiveness exists on a spectrum, right? And ineffective government is not necessarily synonymous with a failed state. So countries with ineffective governments have things like weak economies, high levels of unemployment, and so on. But such a system may nonetheless have a rights protection regime. However, failures in governance could reach such a point that the protection of rights becomes impossible. So we may say something like rights protection depends on some minimal level of effective governance. And I think this is particularly true of structural rights, such as the right to vote, whose existence depends upon an entire infrastructure of political institutions to be even intelligible. Okay, fourth category, effective governance versus rights. And this is just a very small observation here that while most of the time rights and effective governance can be mutually reinforcing, the protection of certain rights can in certain moments undermine the effectiveness of governance. And what I have here in mind here is, for example, the campaign finance rules in the United States or the downside of social media. Of course, I think the positive contributions of individual rights far outweigh the negative consequences, but I think it can be said that certainly in some situations, rights protection can impact effective governance in a negative way. Okay, so to sum up the second point, political systems around the world have different combinations of the two faces of constitutionalism. And so the contours of the relationship between constitutionalism and effective government is therefore deeply contextual. So if we look at some democratic regimes, we may conclude that rights and effective governance can be mutually reinforcing in a positive direction. By contrast, if we look at authoritarian regimes, we might see that while effective governance requires constitutionalism in its positive power generating sense, it can take place without constitutionalism in its negative power limiting sense. Okay, finally, my third point. Now I just want to focus on democracy. So the question is, to what extent is effective governance dependent on constitutional structures when we're just talking about democracies? So Sandy Levinson, for example, has argued that the US Constitution is responsible for producing a dysfunctional governance. However, I think the fact that the level of dysfunction in governance fluctuates over time suggests that the structural features of the Constitution are not solely responsible. And I suggest that the same is true for effective governance. I think that with respect to democratic governments, the quality of constitutional structures is an important factor, but is not wholly determinative of the effectiveness of government. I think instead it is the interaction of various factors, constitutional, political, institutional, and civic, taken together that produces either effective governance or dysfunctional governance. So an interactional approach, I think, takes into account the ebbs and flows of effectiveness and dysfunctions. At some points in time, the relevant factors generate too great a constraint on governmental action, thereby producing dysfunction, whereas at other times, these factors are better aligned, thereby producing effective governance. And so, as I mentioned earlier, I think this demands a very contextual kind of analysis. That being said, in many democratic nations, I think constitutionalism is a minimally necessary but not sufficient condition for effective democratic governance. Okay, so in conclusion, although this is a preliminary sketch, I think that effective governance is grounded in constitutionalism, and conversely, that the concept of constitutionalism contains within it a commitment to effective governance. However, as I mentioned, I think it's a very complex relationship between these two things. I think I'll close by mentioning a few questions that I raise but don't address in the paper. So for instance, does it make sense to speak about a right to effective government? And if there is such a thing as a right to effective government, should it be judicially enforceable? Or on the other hand, is effective government better thought of as a duty or an obligation or a principle? And if so, what are its implications for elected representatives, for political parties, for legislatures, or for the executive branch? And finally, I think a pressing question today is whether political dysfunction or governmental ineffectiveness has become so acute that its impact will not be easily reversible. So in other words, how do we see our way out of the kind of government ineffectiveness that we're seeing in so many parts of the world? Thank you very much.
All right, thank you, Yasmin. David.
Thank you. Let me just begin by echoing my fellow panelists. Thanks to the organizers of this conference, Jacob and Victor, for including me in this wonderful panel. This paper is an effort to consider the place of administrative and bureaucratic discretion in the context of democratic constitutionalism. And in particular, to consider the issue of administrative discretion through the lens of neo-republican theory, primarily but not exclusively, as articulated by Philip Pettit. For a long time, the problems and issues surrounding administrative and bureaucratic discretion have been pushed to the side in various ways in political theory in general and in considerations of both democratic theory and constitutionalism in particular. There's a kind of what Dennis Thompson calls the hierarchical model of viewing government, which he identifies with Hobbes and Locke, that pushes the level of responsibilities to the highest possible level where it's subject to scrutiny. There's the professional model, the other model that Dennis Thompson identifies for considering these issues, which he associates with Hegel, which solves the problem or identifies the problem as a problem of proper socialization of state agents. If they're properly socialized to follow the law and the rule of law, the problem will resolve itself. More recently, Ronald Dworkin characterized famously through the metaphor of the donut hole, right? For Dworkin recognized the existence of bureaucratic discretion and the potential problems that it might create for a rule of law, constitutional, democratic polity. But he imagined that he conceptualized discretion as the whole of the donut, right? That it is bounded by law, that the law creates the range of discretion. And I think recently, political theory has in a variety of ways, begun to confront the fact that these sorts of models are not adequate or useful. And they certainly can't account for anything approaching the nature of the modern administrative state and the inevitability of a wide range of discretion within that state. This paper essentially contributes to that ongoing project. I want to do something perhaps for certain kinds of administrative and bureaucratic discretion and think about its role in a democratic context that in some ways tracks what Arash wants to do for counter-majoritarian features and federalism, which is to say, I want to kind of identify some of the ways and the character that discretion might take that might make a positive contribution to a democratic theory, without, of course, implying that it necessarily is so. So I do this through the first major section of the paper. I work through the theory of the state and neo-republican theory in some detail, and I want to sort of gloss over most of that, but pull out some of the important elements of it for the larger argument. So first of all, I think the neo-republican theory of the state is best characterized as kind of conceptualizing the state in a sort of balancing scenario, right? That there's a recognition that in neo-republican theory, the primary value and objective is to avoid, ameliorate, or limit domination, to promote the value of freedom as non-domination. And so then in conceptualizing the threats to domination, neo-republicans acknowledge two primary forms, dominium and imperium. Dominium is private domination, imperium is public or state-driven state domination. So therefore the model of conceptualizing the state, and I should say I don't get into the details of what that proper neo-republican state looks like, but it looks something not too dissimilar from the modern constitutional democratic state. The way to characterize the sort of goal of the design of such a state is one that is both strong and robust enough to be able to act to prevent dominion as necessary, to prevent private domination, but that is nonetheless controlled and checked in various ways such that it is less likely or unlikely or unable to slip into imperium, domination of the citizenry. And one of the things I argue in this section, and here I'm building on a previous paper published in Polity 5 or 6 years ago, is that imperium is incompletely theorized in neo-republican thought. And there are two categories of imperium that we need to recognize, and we need to sort of treat them differently. And I give them the label of general imperium and partial imperium. So general imperium is the domination of the collective citizenry by the state. And this is done through, in the language of neo-republican thought, through a failure to track the common avowed or avowable interests of the citizenry. Right. So when the state acts contrary to our common avowed and avowable interests, it risks dominating the general citizenry, the collective citizenry. And this is the model of imperium that I think shows up in in neo-republican theorizing primarily. We need to acknowledge and make room for a second form of state domination, of imperium, and I give it the label of partial imperium. Partial imperium is the localized, specific domination of a subset of the citizenry, often with the blessing or indifference of the larger citizenry. So this is still a form of state domination, but it doesn't take the general character of the form of domination that shows up in neo-republican theory. Once we acknowledge that these two forms of imperium are kind of a threat to the neo-republican state achieving its goals and its purpose, I think this helps us shine a spotlight on the problem and the puzzle of the puzzles that may face state actors, right? So much theorizing about bureaucratic discretion is about how to properly contain it, how to sort of prevent rogue actors from undermining the rule of law through excessive discretion and so on and so forth. And that's an important thing to consider. And I don't mean to dismiss that problem. But what I end up focusing on here instead is a problem that may apply to an entirely good faith, a properly Republican state actor who is caught between general and partial imperium in some respects, right? If you look really hard through some of the sort of more minor papers, I don't find it in the major works necessarily, Pettit does address this issue directly a few times, and he seems to come down on the side of avoiding general imperium, right? And if there's this sort of broad social indifference to a particular form of localized domination, and I don't know that that's his consistent position, but I've had difficulty finding him addressing it directly. What I want to do here is not argue for one choice or the other, but to argue that that if we look at the actual world of acts of administrative discretion, we can find examples of actors declining to choose one or the other. So the paper uses three kind of cases of bureaucratic discretion. I talk about those three cases and how a neo-Republican theory might view them. And then I use them as sort of fodder to develop a theory of democratic discretion that is only in the very early forms of being sketched and outlined in this paper as it stands. The three cases, quickly, one of them is famous for those of you who've watched The Wire. You probably recall from season 3, I think the greatest season of television from a political science perspective I can think of. A lieutenant or a major in the police department gives a speech about the brown paper bag, the great moment of civic compromise that is a brown paper bag. He's describing city council passes a law against public consumption. The police recognize that enforcing this law would, on the one hand, criminalize the lifestyles of many of the urban poor in Baltimore, and on the other hand, make their ability to do what they consider real police work, the police work worth doing, virtually impossible by to enforce this law that will surely be widely flouted. And he sort of says this is a compromise. In the speech, he characterizes the initial act of compromise as being done by the drinker who puts their bottle of alcohol in a brown paper bag. And then, of course, the police recognize this compromise and they all use this as a way of avoiding this dilemma and avoiding the sort of partial imperium, general imperium problem that this law posed for these bureaucrats. The other two cases I consider are perhaps less apocryphal, and they are not apocryphal. They are recent historical cases. I talk about a county clerk in New Mexico in 2013, Lynn Ellens, who, despite the broad at that time, New Mexico had not officially legalized same-sex marriage. However, he noticed that New Mexico was one of the states that did not say anything about gender in the law authorizing marriage. So he just began to issue, looking at, rather than the guidance he was given, looking at the authorizing law itself, he began to issue marriage licenses to same-sex couples, which precipitated a minor crisis that eventually led to the New Mexico Supreme Court ruling on the side of his interpretation and effectively legalizing same-sex marriage. And then the last one I talk about is Daca under the Obama administration, which of course, in many ways simply formalized and made a rule the priorities of discretion that the immigration enforcement in his administration had been using in terms of where to focus the energies on deportation, but then also granting a sort of status more amenable to not being dominated to a group of vulnerable residents, the DACA eligible population. And so in thinking through what all these add up to and what they mean, I draw on a kind of stray comment in a book by Charles Tilly about 20 years ago called Durable Inequality, in which Tilly is kind of doing this general theorization of social relations very broadly. And he talks about social shims, is the term he uses. Shims are a sort of trick of carpentry and other technical matters. They're little devices or fixes to larger processes that aren't working as they should. And Tilly describes social shims in this way. In human interaction, people constantly avert disasters and standstills by inserting social shims in the forms of self-corrections, reassurances, clarifications, compensatory actions, and mutual aid. Social processes are worse than bookcases, however, because they keep moving. No shim stays in place for very long. Social structures stick together, more or less, precisely because improvisation never ceases. And I take that conceptualization and I try and begin, and this is the part of the paper that is at this stage fairly sketchy. I try to begin to sort of theorize a category of action, and in particular, a category of action that applies to some state actors confronted with the imperium dilemmas I identify as democratic shims, right? That a particular form of response to those dilemmas of state actors that refuses to simply accept one or the other, either countenance partial imperium or countenance generalized general imperium, but instead seeks to orient other actors towards some sort of future, perhaps provisional, perhaps more permanent settlement, right? So the goal of the Daca spoke to sort of two audiences, right? On the one hand, Daca spoke to the legislature, saying this idea has been around for a long time. The plan to do something kind of like this has been around for a long time for a variety of reasons. The legislature hasn't been able to act. We know the public largely authorizes this. We can see this is a popular idea. And so it's an effort to sort of spur action towards actors above, but it's also an effort to spur action. It's also an effort to provide a kind of provisional settlement, of course, for the recipients of Daca status, right? So it's speaking to two audiences at once. Lynn Ellis's case, of course, is directed both at the legislature potentially, but also more directly at judges in New Mexico who sort of address an issue they had been avoiding addressing. In many ways, the brown paper bag story is directed largely at the governed, the potentially dominated population. But of course, it also ends up being directed not so much at the city legislature to rethink public consumption laws, but at the courts. The brown paper bag works its way into Fourth Amendment jurisprudence, eventually, the poor man's briefcase. So again, as with echoing Arash, there's still room, of course, in this theory recognizes that a great deal of administrative and bureaucratic discretion is potentially democratically abusive and needs to be prevented and curtailed. And this isn't a theory that says that wants to celebrate. One of the motivations for this paper is that when I came to Dayton, I'm the sole political theorist here, but my colleagues who are most kind of oriented towards questions of political theory are the public administration faculty. And some of my public administration colleagues are from what is the Virginia Tech School, John Rohr and Charles Goodsell and other public administration scholars that essentially kind of valorize public administrators and their discretion as democratic heroes. And from a democratic theory perspective, it was a very striking and strange thing. And part of what this project is about is kind of trying to meet them halfway and put that kind of perspective in conversation with democratic and constitutional theory. And this is a preliminary effort in that direction. So I'll stop there.
All right, David, thank you very much. So I have a few comments on each of the paper that I'd like to share with everyone. I'll just remind, if you have questions, please use the reaction button at the bottom of your Zoom screen. If you click on that, at the bottom, you'll see a raise hand function, and you can raise your hand and we'll see a list, and I will get to you as your hands appear. So I'll offer my comments in the same order that our friends presented their paper, starting with Arash. So Arash, I love the paper and I share your intuitions. It strikes me that majoritarianism, at the very least, cannot be the whole story, maybe not even part of this, maybe not even a major part of the story, and maybe it does have the kinds of problems intrinsic to it that you point to, in particular with respect to political equality and persistent minorities. if I have a concern, it's that, of course, you didn't belabor us with the technical machinery that you brought to bear in the paper in the presentation. But one of my worries about that machinery and the purely quantificational approach that it takes is that, and I don't doubt that majoritarians and the voting literature uses this, and that's the context you're writing in. But it strikes me that if this is really what majoritarianism stands for, then even modest majoritarianism, for a number of reasons, just seems really implausible. And it makes your arguments, to me, seem almost too strong, almost too good, in that majoritarianism doesn't really seem to have a chance of getting out of the blocks. So I take it that the basic intuition driving majoritarianism, independent of all the equations, is something like the intuition that Henry Richardson draws on in Democratic Autonomy, which is that if you don't have some sort of majoritarian voting procedure in place, then you build in inherently to your public decision-making processes a bias to the status quo. That is, you build in a certain bias toward conservatism, because the few in that case can dictate to the many. So there has to be some kind of voting mechanism in place when unanimity is not available, when consensus isn't available, and we have to make tough decisions. So if that's right, then I'm wondering about whether some of the arguments that you attribute to majoritarianism, that is, that they think that, why majoritarianism is really good is because it allows us to maximize voting power. I wonder if that's really an argument that perhaps some of them make it, but if that's really the best argument that can be offered for their position, because that just seems to me, it seems that in some way that at times, I was having difficulty following in the paper when you're talking about maximizing voter power, whether you're talking about that in the aggregate or for particular individuals, because it doesn't, in the aggregate, right? So because it seems that if it's for particular individuals, the way to maximize voting power is to have as small a community as possible. Then you'll have proportionally greater voting power. But if it's in the aggregate, then that means that it's a compromise. The majoritarianism is compromised as soon as we move away from a world state, right, where everyone is enfranchised. Because everything less than that, even the sort of multi-state territorial world we live in, would seem to be, in principle, a compromise of majoritarianism, if what's really driving the project is a concern about maximizing overall voting power, by voting power we mean the power, as I understood it, that can be aggregated to drive an outcome in the majority. So 50% plus one in as large a pie as possible. So that was one concern I had. The other concern I had, and now you get to this at the end of the paper, and I think you're very honest to say there's no magic formula, there's no magic way to tell when there's a persistent minority of the kind of quality that requires structural reforms. But I think you helpfully point us toward structural considerations and away from personal preferences, except as possible proxies or outcomes of structures that are in place that provide for or create situations of oppression or persistent minorities. It's still, I think, a very live question. At what point do we stop federalizing? So let's say that we live in a federal unit such as Canada, where French Canadians have Quebec to call their home, and they are able to exercise sway as a persistent majority here. But within Quebec itself, of course, First Nations would say, well, we face just the same problem. And of course, I think, the proper response for you that I sense is intimated by the things that you say at the end is, yes, exactly. There should be some sort of horizontal federalism that would include them to be able to be efficacious as well. But that was just something I was wondering about, that in the discussion period you might wish to speak to. Yasmin, so I thought your paper made so much good sense. It's very hard for me to even sort of find something really to disagree with. So I'm just going to ask for some further elaboration. And the elaboration that I'd love to hear about, if it doesn't get in the way of other people's questions, is what do you take to be the relationship between the two faces of constitutionalism? On the one hand, you say constitutionalism has to do with limits on political power, and on the other, with the generation of political power. But it strikes me that there's another aspect to constitutionalism that goes unstated, or at least it's not stated explicitly just by those two, just by the distillation of those two faces or aspects of constitutionalism. And that is the idea that any constitutional project, any constitutional polity, will at the very least implicitly make a claim to possess legitimate authority over the people whom it claims jurisdiction. And I'm just wondering what the relationship is between those two, the two aspects of constitutionalism that that you describe, and effectiveness, and the claim to legitimate authority that I think all constitutional legal orders must make to, in fact, be constitutional legal orders. Okay, David. So again, I really love your paper. I'm very sympathetic to the idea of non-domination playing an important role within a constitutional legal order. I do, however, and I really like the CDA, the creative democratic agency idea that you introduce toward the end of the paper. I do want to ask, though, whether you think it's really necessary to imagine that administrative officials have to adopt what you described as two roles. One, their role as an official, and the other, their role as an individual with a conscience that can, and I take it that it's their conscience or their sense of good citizenship and their sense of being attuned to non-domination that would lead them to use these shims, these democratic and social shims that you talk about. I wonder if it wouldn't be enough to simply imagine that public officials could take very seriously the idea that as public officials, their powers are always constrained by the purposes and intents of the statutory mandates they're charged with overseeing and implementing. And from that perspective, that those statutory mandates are always presumed to be implemented consistent with some principles of equity, principles of procedural fairness, principles of reasonable interpretation. And if you built that sort of a rich, sort of common lawyer's approach to statutory interpretation into what you take to be the role of an official, whether that wouldn't be enough. So, for example, in the case of in the marriage case that you discuss, it may have, the law is of course silent, and so you describe the position that the official takes as a formalist position, that sort of where she essentially takes advantage of the fact that the law is silent. But couldn't what she is doing be precisely what courts have been doing in the UK ever since the 1998 Human Rights Act said that all UK legislation, to the extent that it's possible, has to be read in a manner that is consistent with the requirements of the European Convention on Human Rights, notwithstanding that there may have been prior interpretations that, for example, and there are cases on this, that, for example, silent legislation or even offensive legislation was used to limit marriage and the effects of marriage to opposite sex couples. Couldn't it be that an official could just say, listen, I'm not an originalist, I'm a living tree. I interpret legislation within the social and legal context within which it appears to me. And that context is one that in which the interpretation of our Constitution has evolved, and we have a homegrown Human Rights Act that's evolved as well. So that would be a question I'd be interested in hearing from some. So that's all I have. Now we do have, I'm not sure if either of you would like to respond with like 30 seconds or a minute, or we could go, I can see that we have 5 hands up already. So I am anxious to get to our participants, but if we can just go maybe once around the horn quickly, starting with Arash, if you have anything to say, and if you don't, and you just like to get to the questions, that's fine too.
Maybe I'll just, you made 3 points, maybe I'll just respond to the first 2. So the point that you're making about the status quo bias, that if you depart from majority rule, so that's not true. It's not true, it's only true under specific circumstances, because this basically, majority rule respects the condition of neutrality. Supermajority rules don't, so they have a status quo bias. But the intuition here is that when you have vetoes for various minorities, that's a status quo bias, right? That's, I think, behind the intuition. But not all counter-majoritarian institutions work this way. So, for example, if you give greater voting power to some voters, that does not give you a status quo bias. And actually, federalist institutions, particularly vertical federalism, where you are giving jurisdiction, for example, to provincial governments, that doesn't necessarily introduce a status quo bias. That just distributes, who's making the decisions. And I would argue that actually, there's an argument for why it is that federal institutions can counter status quo biases, because what they do is, by giving jurisdiction lower and having several jurisdictions, they allow for pluralistic experimentation with various kinds of policies. So you can, in the Canadian case, like, you've got heavily subsidized daycare in one province in Quebec, and that becomes a kind of model from which the federal jurisdiction is now drawing on. So it might have been much more difficult to counter that status quo, if you like, if you didn't have federal institutions like this. The second point that you make that I'll respond to is about the aggregation. Yes, it's maximizing voting power. The way that I formalized it there, it presupposes that you already know. In other words, you've already answered the boundary question. It presupposes that we're talking about maximizing aggregate voting power amongst those who you take to be already those with standing in the political decision-making process. So in a way, it's taking for granted the boundary question. Most majoritarian Democrats typically do not themselves defend majoritarianism in terms of maximizing, voting power. That's more of a finding that the things that they do defend, namely come as close as you can to majority rule, turns out to be mathematically equivalent to it. So it's kind of like a kind of analytic discovery, if you like, about that I'm pressing on them. So maybe I'll stop there.
Yasmin.
Thanks so much for those very helpful comments. I guess it's a really interesting question. I was just trying to think right now about what the connection might be between the two faces of constitutionalism and a state's claim to legitimate authority. So it seems to me, and this is just first cut at your question, it seems to me that the power limiting face, I think we might say, to use David's conception of non-domination, we might say that the exercise of power has to follow, in this kind of power limiting non-domination sense, to follow those ideals in order for a state to be able to claim legitimate authority. And I wonder too whether we should be saying the same thing with respect to the kind of the power generating face, or the positive power face of constitutionalism. That is to say that legitimate authority also depends on the state actually furnishing effective governance. Now, I'm less familiar with what has been said on that particular point, but I'm looking forward to finding out more whether, in fact, legitimate authority should, in fact, or maybe people have already made the case that it necessarily implicates effectiveness of government, so that if a state is not actually providing healthcare or dealing effectively with COVID or whatever it is, it has in some sense undercut significantly its legitimate authority or its claim to power. Thanks.
Okay, David.
Thank you. That's a great question. I'm going to try and be really quick so we can get to as many of these other questions as possible. I think that, in a sense, I find that strategy you outline, attractive, particularly in the marriage case, and presumably some other cases where certain state actors find themselves in some version of the kind of dilemma I've tried to outline. I think the reason I would resist that as a sort of general strategy is there's a couple of reasons. One is that the sorts of dilemmas that the wide range of state actors who have the capacity to exercise discretion might face, there may be many contexts where that particular justificatory narrative doesn't do too much work for them, right? And secondly, I think it's that's a sort of narrative and kind of approach to this question that may be available to someone in the position of Lynn Ellens, a county clerk, judges, but it sort of presumes perhaps a higher level of legal thinking than perhaps many people who find themselves with this particular dilemma might have access to. So that's one of the reasons I might want to resist it as a general answer to the problem, to the question that I posed. So thank you.
Okay, great. So let's go to our many desiring participants. Guillaume.
Yes, my question is for Arash. First, how are you doing? It's good to see you. So when we teach democracy to our students, right, one thing that we normally go through is that we teach them democracy in terms of majoritarian institutions and consensus institutions, right? And so, for example, like consensus institutions being bicameral legislatures, and majoritarian ones, things like first past the post electoral systems and things like this. And I guess what I want to press you on is I want you to know how what you're arguing goes a little bit further for us than you just like rediscovering and reaffirming that consensus institutions are good for minorities and in democracies for those values that you say that democracies are predicated on. And relatedly, I also want, like, I know that you gestured towards this, but I want to know if there's not something a little bit more of a, like, I want to push you on a positive, like a normative prescription to make so that certain groups in smaller polities like Quebec, for example, right? There's Dr. Fox-Decent mentioned the example of First Nations in Quebec, or even to go back to the example of French Canadians, right? Dr. Fox-Decent said they have a home in Quebec, but only some French Canadians have a home in Quebec, right? A lot of them are in Ontario, for example, and they do not have the rights or the power that we have here because we're territorially concentrated. And we saw that tragically recently with the debacle with the Laurentian University, right? They can't act or exert the same pressure that we can here in defense of our own people and our own rights, right? And so what do we do in smaller polities that cannot federalize, right? So what kind of solution is available to us here?
Great question. So one of the things that I argue in the paper is that, well, one of the moves that I make in the paper is that I understand democracy not as defined as many political scientists do, with reference to a set of institutions. So when the political scientists typically start out, they say, well, democracy means elections. That is not my starting point. My starting point is normative. Democracy, as I take it, is a commitment to political agency and political equality. And then the question is, what's in the institutional toolbox that under certain social political circumstances can be used to serve those core democratic commitments? So when I talk about federalism, I'm using that as an illustrative example within a particular context that I'm situated in, as an illustrative example to show institutionally what this might mean under those particular circumstances. But it's not the case that I'm arguing that federalist institutions are going to be the answer to all of these questions about the power of numbers or persistent minorities. And so you're absolutely right. Under conditions, for example, if we're talking about Franco-Ontarians, they're not going to be served, their political equality will not be served necessarily by having federalist style institutions. What I argue in the paper is that we have to think about what are the other kinds of institutional measures that can be taken. Sometimes it has to do with the party system. Sometimes it has to do with the structure of the parliament, and so on and so on. So there's, the question of institutional design is not determined by the argument that I'm making, but rather it is an invitation to think about institutional design under those particular circumstances. When, for example, when a minority is not territorially concentrated. So that's what I would say. And one other thing I'd say is that my argument is not an argument for consensus institutions, if I understood your point correctly. Consensus institutions are the ones that precisely have the kind of status quo bias that Evan was referring to. Maybe under some circumstances you want to give veto power to certain, but that does have the problem of status quo bias. In the general argument is not about consensus institutions. It's about the distribution of power within the decision-making process.
Thank you. Ryan Flynn.
Thank you very much. My question is directed at Yasmin. I find the focus on responsible government to be very compelling. It's in fact something very important to our history because it's what spawned 1838. My question is that it seems that your point about responsible government as an almost fiduciary responsibility that the courts can enforce is almost already enforced insofar that democracy does that as an accountability and filtration process, and then other things that would be a dereliction of the duty to govern, such as treason or corruption, are already illegal. And so my question is, do you think that conception is a bit too narrow, or do you think there are cases that are not treason or corruption that are still a dereliction of the duty to govern?
Thank you. That's a very interesting question as to what are the sort of the floor and the ceiling on effective or ineffective government. And I think, I can see how a minimalist account might say, look, ineffective government, we want to try and define it fairly narrowly in the way that you've suggested, right? That it comes about with something like treason or corruption, something really quite obviously problematic. And I think it is a question as to whether we want a more minimalist account of what effective government adds up to, or what responsible government adds up to use your language, or do we want a thicker account of effective government such that, we think it's more than just avoiding the really terrible things like corruption and treason, that we actually have somewhat some sort of ceiling, or that they're aiming towards, where we might say it also means other things like making sure that there are enough vaccinations to go around, or making sure that children have access to education and so on. I think that's right. I think effective government, what do we mean by that category, is also something that's contested. And certainly, there are different accounts. Some people, for example, would say it just cannot be effective government if it's not democratic. It has to be democratic. So talking about authoritarian regimes as being effective just doesn't make sense. So yes, I take your point, and I think it's a very great insight. Thanks.
Turku.
Yeah, this is also a comment about Yasmin's paper, but I think it nicely follows on from that exchange. So effectiveness is an intuitive concept, but I found it a very slippery one to work with, when we look at it closely. It tends to be ends oriented, I think. So we evaluate the effectiveness of public institutions by assessing how well they produce certain desirable outcomes. But that presumes that we know what the desirable outcomes are and who they're desirable to. So, or we might think that effectiveness, presumes acting in the interests of the governed, but the interests of the governed are pluralistic and conflicting and fluid. So whichever way we cut it, the mechanisms for adjudicating what these interests are, or what, for designating what desirable outcomes are, is endogenous to the constitutional system, right? So the Constitution is the mechanism, sets out the mechanisms for deciding what desirable outcomes are what the criteria of effectiveness are. So that was one kind of issue that I found difficult in thinking about the relationship between constitutionalism and governmental effectiveness. The other comment I had was to kind of urge a distinction, and the distinction I think is there, but just more in the interest of trying to think through it myself, between what you call the second phase of constitutionalism, its power building role, and effectiveness. Because we can think of power, but that doesn't meet the effectiveness criterion. So because, for instance, it's only effective at protecting the interests of regime cronies, that's a use of power that, is effective, but only in a certain way. So how much kind of normative stuff to build into the concept of effectiveness seems to me to be tricky. And then one last kind of stray observation is, I think the subsidiarity principle is a nice place to see the a logic of effectiveness at work, because where the delegation of power to a higher level is typically justified with reference to something like effectiveness, particularly in sort of coming together federation type polities, while there's a presumption that the lower level is better at democratic on the democratic legitimacy scale. So the upper level has effectiveness legitimacy, while the lower level has democratic legitimacy. And I think that goes a little bit to Evan's question about how legitimacy plays into this. Thanks.
Thanks so much. Those are great comments. And I think I agree with all of them. I think that, to what extent, I definitely think it is endogenous in the way that you're describing, that we get ideas about what effectiveness is from the very constitutional system, which we're trying to make sure is effective. I think that's right. And I guess one sort of possibility is that we may just think that is there some sort of objective view as to what effectiveness is at a very abstract level, like just, for example, making sure that society's basic needs are met, something very abstract like that, with the recognition that individual places will have a very different understanding as to what those basic needs might be. But to sort of say at an abstract level that we can think of that sort of definition might actually take into account your concerns around the endogeneity and the fact that there is difference across different countries. On your second point, I'm going to have to think about this a little bit more. The normative aspect, I think, is really important, and I think that you actually addressed some of this in your book. I agree. I think it's hard to know how much to build into the concept of effectiveness, what we mean by it. So, for example, if an authoritarian regime is effective because, as you say, all the cronies are happy, or because the powerful people are happy, is that effectiveness? Or does effectiveness mean that the average person is in fact having their needs met? Another possibility is to say that we really care about effective self-governance, to sort of build in the normative requirements of democracy, to say that effectiveness, we can't even really talk about it outside the scope of thinking more broadly about everyone, because effectiveness where only the cronies are happy is tyranny, perhaps, right? Maybe it's maybe that's just another word for tyranny or oppression, that certain people's needs are very effectively met at the expense of everyone else. And so maybe the word effective shouldn't be working there. So I agree. I think that there is a normative dimension to how we think about effectiveness. And I'll think further about that. Thanks very much.
Thank you. Mariah Seisberg.
Hello. Thanks everyone for this fantastic panel and commentary, and just to everyone who's here. I'm really getting a lot out of it, and I'm glad it's happening, even though it stinks that it's on Zoom. So I think my question is for both Arash and Yasmin. It's about the kind of discursive world that would link up with the theoretic arguments that you're offering. Because so I'm going to pitch it to Arash because that's how the question first positioned to me, but I think it applies more broadly. and I completely agree with your paper that there's nothing intrinsic about federalism per se that makes it pro or anti-democracy. And the presentation sets up this, kind of like we have the Canadian example with minorities of Quebec, and then we have the U.S. example with minorities of, racist white voters. But it seems like multiple co-realities is probably, although we focus on specific examples, most polities are going to have multiple co-realities. So I was thinking about in the United States, the way that the Senate empowers rural white voters versus the way drawing majority minority districts empowers Black voters, right? The way that the different delegation structures privilege different minority groups, and some of those minority groups have there are democracy concerns associated with empowering them, and some of them not so much. So in an empirical context where you have multiple kind of co-realities of different minorities, some of which are problematically overrepresented, and some of which would be an improvement of democracy to delegate power in a way that empowers them. What's the discursive world in which that is navigated through? And I think this is very similar to the question that Yasmin just got, because there's a politics to this. There's a politics to announcing, we need to empower this minority. This minority has a claim here that's worth consideration. This minority is not disenfranchised because their ideas are bad and their perspective is worthless. They're disenfranchised because there's stigma, or because they're culturally at odds with others. There's a world of justification that needs to happen in order to talk about differential voting rules. And in a context where you have multiple co-realities at the same time, or where you have change over time, where at one point a set of voting rules empowers an underpowered group, and another context, historically that same rule disempowers them and empowers people who are, more problematically viewed players. What kind of discursive structure engages with that shift in order to meaningfully update it or address it or be sensitive in multiple empirical situations? And I think that's really a question for both, because it's about the politics of designing institutions where you're kind of explicitly saying, we're going to design our constitutional institutions in a way that serves specific values, which in fact are highly contested. The value of including cultural minorities or racial minorities, that's contested.
Thank you. Arash, do you want to start, and then Yasmin? Arash, you're muted.
I'll be brief because I can see a queue. So that's a great question. And I think that's part of why I'm shifting the focus away from particular institutions as being constitutive of the democratic commitments towards this focus on equality and agency. So I think the language that I would use in politics when talking about democracy is not about majority rule, is not about popular sovereignty, is not about all these other things that people associate. It's about equality and agency. And those become, I guess that's the way that I would, insert myself discursively into these discussions. And about particular groups, then let's have a debate about equality and agency. And agency and equality, as I conceive them in the democratic tradition, have to do with power. And so let's, people talk about privilege, and I have a different paper arguing that actually this is about power, and we should be looking at questions about the distribution of power.
Yasmin?
Thanks so much, Mariah. I agree. I mean, with what you said, I think it is, and this goes to Turku's point as well, it is actually highly contested. And now that I'm thinking about it further, different people might have different views as to when a government is being effective, right? Is it, what exactly has to be provided for there to be effectiveness in government? And that is going to be, that is in fact already a source of tremendous political disagreement as to what should be the priorities or what shouldn't be. And it might actually be easier, to think of it the other way, to think about dysfunctional governance rather than trying to define effective governance and to agree on that. We might actually have more agreement if we think about what it means to be dysfunctional. and how, what a dysfunctional government looks like. But granted, there might be a disagreement on that as well. Thanks very much.
Excellent. Francis Valcourt-Hébert.
Hi. Well, I want to start by saying I'm really happy to be here. Great presentation, everyone. I guess my question is to Prof. Abizadeh. And I mean, I guess some of the provisions that Prof. Dawood was saying. So do you think that there's still a place for limiting the freedom of choice of French Canadians wanting to attend public English schools, especially the ones that their families might not be able to afford private institutions, considering that we're shifting towards a digital world where English is a vital tool, even almost predictor of employability and future success. In a way, I guess the effectiveness that Prof. Dawood was inquiring on at preserving the language rights might be damaging the very population it kind of aimed to protect. So I wanted to know what you guys thought of, well, maybe shifting away from preserving the French language protection rights on French Canadians, and maybe even allow them to integrate the maybe broader environment of politics. So like we saw in the Bloc Québécois, maybe if the French Canadians of outside Montreal would probably focus a bit more on well, issues relating to the province as a whole and less about protecting or being served by the federal government in a way.
Great. So what I think what your question does is it highlights a feature of the argument that I'm making in the paper that I didn't make explicit, which is that the argument of the paper does not address the kind of question that you're asking. In other words, it doesn't address the kind of question about, typically when people are criticizing majoritarian rule or majority rule, they do so on the basis of, well, what about, how do you protect individual rights? How do you, from a liberal perspective, they're arguing, look, that maybe there should be limitations on majority rule in order to protect individual rights. If majorities, it's the worry about tyranny of the majority. This is not the kind of argument that I'm making. I'm not criticizing majority rule on the basis of answering the kinds of questions that you're asking about protection of individual rights, about, which are, I think, are at stake in the kind of question that you're asking. So in a way, my argument doesn't really speak to it. But it does help to clarify the nature of the, I think your question helps clarify the nature of the argument, which is that it's a democratic argument rather than a, democracy versus liberalism argument.
Okay, we're running, thanks, Arash. We're running low on time, so I'm going to ask Victor and Jeff to ask their questions quite quickly. I have a question I'd also like to ask David, so I'm going to add mine on at the end as a third question, and then we'll let our participants have the final word. So, Victor?
Sure. So my question is for Arash, and I think it plays on the interplay between the other paper that he's referred to and this one, because you have a very capacious understanding of power, namely having to do with the satisfaction of the interests of the agent. And I'm thinking in terms of an argument that's been presented recently south of the border about, say, representation, equal representation of rural states in the Senate, over-representation in the Electoral College. And the argument is essentially urban centers, and especially coastal urban centers, control the production of culture. They effectively set the cultural agenda for the country as a whole. So political overrepresentation compensates for cultural underrepresentation. I'm wondering if there has to be a common currency of power, say representation or agenda setting, for these kinds of trade-offs, counter-majoritarian trade-offs to occur, or if this is a kind of illegitimate argument that is trying to smuggle in some other considerations that are better addressed through other means.
Thank you. Jeff?
Okay, really quick. My question is for Professor Watkins, and it's about the New Republican argument. that you're making, and my question is about. I noticed in your examples that most of your cases where there's an administrative actor that's going rogue in some way or exercising discretion in some way, there are cases where the outcome is particularly pleasing to most left liberal Democrats, which would be probably a lot of us in this chat group. So what about cases though where an individual actor, there's lots of people out there who have right of center and far right points of view, and what happens when those actors become administrators and bureaucrats and they start exercising their discretion in ways that align with their substantive judgments about what's just in a political order? So you can think of like an example, like I think the counterpoint to your New Mexico example is the example of the clerk in Kentucky. I forgot what her name was. She was sort of a martyr on Fox News for a little while, and she was refusing to issue marriage certificates in spite of the ruling in Obergefell, because in her view, it was a very deeply unjust conception of marriage that was being established by the state. So it's sort of the old Creon problem, but what I wanted to get at in pushing you to sort of say something about the other side of where there's maybe some clerk where you have Kim Davis. Thanks, Guillaume. That was her name. I've just forgotten her. Sorry. What I think though is highlighted when we think about the case where someone who may have substantive judgments about what's unjust imperium may be in those positions, what those kinds of cases highlight is how we may all agree, that in some really deeply structurally unjust states, we want people to just exercise discretion in ways that they think are substantively just. But we also want that threshold to be a pretty high threshold of some kind in a democracy, because if we're all making our judgments about it, what's truly just imperium in the exercise of state power, then we have the worst of both worlds in a way. I pose the question, don't we maybe have the worst of both worlds on the Republican story there, where individuals are not only exercising their discretion and substituting their judgment about what's just state action for the democratically enacted, along some lines, a judgment of what the statute says, let's say, or what the constitutional law says that's enacted by a supermajority or whatever. You also are potentially exercising dominion, private domination, over the particular citizens that are coming within your little domain of power, your little exercise of authority. And so this is my question, is just to say, I really like your project. I really think it's interesting. And it's really pushing on some of the fundamental issues in the Republican sort of structural story. But what I think might be helpful is just thinking through some counter-pressured examples, And I think you're right that there's a there here, where like there's some story about how discretion then can be exercised below the threshold of just this whole system's unjust in ways that still make imperium less dominating on the Republican story. And one sort of mini suggestion I have, this occurred to me while you're talking, is that Elena Kagan has a really famous article about how bureaucrats become more democratic the more directly they're related to presidential authority and executive actions, because the president and the executive in the American context has a separate democratic mandate, right? So your view on that account might be, look, the usual story is that there's this room for the discretion needs to be hived off when it comes to enforcing home statutes, because we're getting away from the enacted authority of the people. But maybe on the Kagan story, the more we get that, the more that power is exercised closer to a particular democratic mandate, the more it's closer to something that's justifiable in terms of imperium. And I don't know if that makes any sense, but it's just a little idea.
That's great. Well, Jeff's question for David is better than mine. So why don't we just leave it there, but have Arash and David, Arash, if you'd like to respond briefly to Victor, and David to Jeff. Arash?
Briefly. I do think that political equality does require us to pay attention to that capacious understanding of power, Victor, that you're pointing to. So I do think that political equality requires attention to structural power, and that requires attention to outcomes. However, the argument that I'm making here is not about political equality generally, but it's about democratic equality, which I understand in agency terms. So it's actually not drawing on a broader notion of power in that way. It has to do with agential power in decision-making processes. So just to clarify, it's not about satisfaction of interest. does the example that you give, does it sort of connect with the argument that I'm making here? I don't know. I'd have to look at the details, more in depth. I just don't know I don't know the argument well enough to be able to tell you it's possible. Depends on what kind of social structures are in play. So I just don't know.
David.
Thanks. That's a great question. It does just so happen to turn out to be the case that there was a line in my paper that warns that for every Lynn Ellis, there may well be a Kim Davis lurking in a clerk's office somewhere. So a couple of things. First of all, I want to characterize this project as describing more than authorizing. Right. So one of my conceits is that this kind of democratic action, this kind of creative democratic action is happening. Abuses of power are also happening. Let's kind of characterize what's going on, and then perhaps work backward from there to think about the ways administrative states could be designed to promote one or the other, to promote the latter and diminish the former and latter, whichever that turned out to be. But you also raise a point that I don't have a great answer to, right? Which is that I, in this paper, kind of operate within a kind of neo-Republican conceit that what is domination, particularly once we move away from general imperium and think about dominion and partial imperium, that what constitutes domination is something that we may not agree on, but we should be able to agree on. That there's some sort of general standard we can apply that's sort of outside of the realm of our ideologies and our broader political views. I don't, my all things considered view is to not endorse that conceit of neo-republicanism, right? I don't think that's quite right, or there's a part of the story that's kind of, that's definitely missing there. So all that is, well, my official defense against that particular worry, I don't. Yeah, that's something I'm still kind of I'm unsettled on how to think about precisely that problem. But I appreciate the push in that direction.
All right. Well, please, if everybody could join me in thanking our three panelists for a wonderful discussion.
Thank you, Evan.
It's a whoops.
Thank you so much, Evan.
I'm raising hand instead of clapping, but there we go. Thank you so much, everyone. I believe we will meet back again at 2 p.m. if I recall the 2 p.m. if I recall the Eastern time. If I recall the schedule correctly. So thanks, everyone. Have a wonderful lunch. It's a shame we can't dine together, but we will see everyone soon.